Hi everyone, it's attorney Bianca Jordan from brazenlegal.com. Thanks so much for watching today's video. Please be sure to subscribe to the channel so you don't miss the next one. Today's video is on the extension of the April 2020 executive order. So back in April, this administration issued an executive order to prohibit certain immigrants from coming into the United States due to COVID-19. This administration believes that prohibiting immigrants from coming into the United States will protect American jobs since a lot of Americans lost their jobs due to COVID-19. Specifically, the executive order barred parents of U.S. citizens, siblings of U.S. citizens, sons and daughters of U.S. citizens if they're over the age of 21, children of green card holders, as well as spouses of green card holders. And within the original executive order, the administration said that within 50 days, it would determine whether or not to extend the executive order. The original executive order was supposed to be in place for 60 days, but within 50 days, they would revisit to determine whether they needed to renew it or extend it. Additionally, within 30 days, they said that they would re-examine to determine whether they needed to add non-immigrant visas to the ban as well. So non-immigrant visas such as visitors visas, fiancé visas, and certain employment visas such as the H-1B and the H-2B. So today, this administration issued a new executive order which extends the original April 2020 executive order to December 31st, 2020, and it can be extended beyond that as needed. It also expanded the executive order to include certain non-immigrant visas. So specifically, it is including the H-1B visa, the H-2B visa, the J visa, and the L visa. The H-1B visa is a non-immigrant visa. It's an employment visa. The H-2B visa is also an employment visa for agricultural workers. The J visa is an exchange student visa, and the L visa is also an employment visa as well. So specifically, the executive order includes these visas and it also excludes the family members as well. So for example, H-1B visas, your spouse and child are able to get a visa as well to come to the United States. So under this executive order, that won't be able to happen anymore for H-1Bs, H-2Bs, J visas, and L visas. However, similar to the April executive order, this new executive order only applies to people that aren't in the United States. So if you're already in the United States with one of these visas, this executive order does not apply to you. This executive order does not apply to immediate relatives. So if you are married to a U.S. citizen or your mom or dad is a U.S. citizen and you're under the age of 21, then this executive order does not apply to you. It also does not apply to you if you're coming into the United States to perform temporary labor or services essential to the United States food supply chain. It also doesn't apply to anybody that this administration might deem in the national interest to come to the United States. So for example, if you're coming into the United States to help deal with COVID-19, then you might be able to still come into the United States. So again, this executive order is now extended until December 31st of this year, which we kind of knew was happening. The president, during a news conference a couple months ago, was asked if he would extend this, and he said that he would consider it, and if so, it would probably be extended through December. And that's exactly what's happening. And this is an election year. The president does want to appear tough on immigration and appear as if he's trying to help American workers. And considering last week's victory in the DACA case, he definitely wanted to do something to show his base that he's still tough on immigration and wanting to protect American workers. So they extended the executive order. Despite this extension, though, it is still possible to work on your green card applications, to work on your immigration cases. It's still very much possible to come to the United States despite this latest obstacle. So I want to reiterate that this executive order does not apply to people that are already in the United States. So if you are in the United States, you can still apply for green cards. You can apply to adjust your status. If you are a green card holder and you are thinking about petitioning for someone, or you want to petition for someone who is now barred from this executive order, if you're eligible to apply for U.S. citizenship, you should definitely do that soon, not only because the filing fees are going to be going up soon, but also because depending on the person you're petitioning for, they're not included in this executive order. So if you are, for example, you have a green card, you've had a green card for 5 years, and you're married to someone who doesn't have a green card. If you become a U.S. citizen, then you can petition for that person to get a green card, and they would still be able to because they're not included in this executive order. They would be able to adjust their status depending on how they came to the United States in the first place. Another option is if you haven't started the process yet, you can start by filing the I-130, even if you only have a green card right now, because if you eventually become a U.S. citizen before this executive order ends, or even while the executive order is still around, getting the ball rolling on that case will definitely help you, because it will help you so that you don't have to wait as long as you might otherwise be waiting if you're waiting until this executive order is over. Because again, the executive order is in place until December 31st of this year, but it can be extended beyond that. So if he gets a second term and decides to keep this going, then that executive order will continue to go, and your family members will not be able to come to the United States. So it's still worth it to at least start the process of, filing that I-130, getting that approved. Depending on where you are, the I-130 can take anywhere from 6 to 8 months to approve for a U.S. citizen, or for a spouse of someone who's trying to come to the United States. So it just really depends on where you are and who you're petitioning for. But definitely get the ball rolling. If you haven't yet filed an I-130, I would start doing that. The process is going to get more complicated. There are going to be more bars and obstacles to getting your green card or your visa or whatever immigration benefit you're trying to apply for. So definitely start getting that ball rolling. And also, if you are already in the process of consular processing, waiting for you to get your interview at the embassy, or even if you're waiting for the National Visa Center to send you that welcome letter with a checklist of all the documents that you need, start gathering those documents now anyways, even though you won't be able to get an interview while the executive order is still in effect. But at least you can get the ball rolling and gather those documents so that as soon as the executive order is lifted, you could really hit the ground running. So again, the April 2020 executive order has been extended to December 31st, 2020. It impacts parents of U.S. citizens, siblings of U.S. citizens, children of U.S. citizens if they're over the age of 21, and spouses and children of green card holders. It now impacts people who are trying to come into the United States with an H-1B visa, and those that are trying to follow their family members to the United States with an H-1B visa. It impacts H-2B visas, J visas, as well as L visas, and the relatives that would have been following them into the United States. Definitely reach out if you have any questions about this new executive order or your immigration case. You can visit brazenlegal.com to learn more about me and my law firm. And please don't forget to subscribe to the channel so that you don't miss the next video that comes out. Thanks so much for watching.